It's 2025, which means Tennessee and Minnesota have entered the data privacy landscape with sweeping new laws. These aren't just regional regulations, they're part of a growing national trend towards stronger consumer privacy protections and more rigorous corporate accountability. If your organisation handles personal data from residents in either state, now is the time to prepare. Tennessee's Information Protection Act, TIPA, and Minnesota's Consumer Data Privacy Act, MCDPA, share a common goal: give consumers more control over their personal information and require businesses to treat that data with greater care. While these laws align with many of the frameworks we've seen in other states, they do introduce some important distinctions and some new obligations. Let's start with applicability. TIPA targets mid to large scale operations. So if your business has an annual revenue exceeding $25 million and you process the data of at least 175,000 Tennessee consumers per year, or if you derive over half of your revenue from selling personal data involving 25,000 or more consumers, then you're in scope. Minnesota takes a slightly different approach, so the MCDPA applies to businesses processing personal data from 100,000 consumers annually, excluding payment transaction only data, or those that derive 25 or more of their gross revenue from selling data involving at least 25,000 consumers. And here's an important distinction. Minnesota exempts small businesses unless they engage in the sale of sensitive data, in which case they're required to obtain opt-in consent. So even if you're a small or mid-sized operation, that exemption may not apply if you're handling high-risk data types. Both laws revolve around how businesses collect, use, and share personal data. At their core, they define personal data as information that is linked or reasonably linkable to an identifiable individual. But when it comes to sensitive data, each state carves out its own criteria. Tennessee includes categories like racial or ethnic origin, religious beliefs, health diagnosis, biometric data, sexual orientation, and citizenship or immigration status. Minnesota mirrors many of these but expands the definition to cover genetic data, precise geolocation, and any personal data collected from known children. Understanding these definitions is critical because handling sensitive data triggers additional compliance obligations, including risk assessments and opt-in consent mechanisms. The consumer rights granted under both laws are robust and multifaceted. Individuals have the right to know if their data is being collected and processed, to access that data, correct inaccuracies, request deletion, and receive a copy in a portable format. Both laws also empower consumers to opt out of key practices such as the sale of their data, targeted advertising, and profiling that has a legal or similar significant impact. Minnesota goes one step further. It provides transparency and recourse around automated decision-making. Consumers not only have the right to opt out of profiling, they can also question decisions driven by algorithms, ask for an explanation, and request a path forward towards different outcomes. For businesses using AI or profiling in hiring, lending, or other consequential decisions, this is more than a formality. It may require operational changes. So what's required? At the foundation is data governance. Both states mandate that businesses establish and maintain reasonable administrative, technical, and physical safeguards to protect personal data. Transparency is another pillar. Organizations must present clear, accessible privacy notices that deal with what data is being collected, why it's being collected, with whom it's shared, and how consumers can exercise their rights. Data minimization also plays a central role. You could collect only the data necessary for a clearly stated purpose and nothing more. And then there are third parties. So both laws require contracts with processors that define the roles, responsibilities, and security obligations. These agreements aren't optional, they are part of your legal risk framework. Your privacy policy can no longer be generic, one-size-fits-all document. Under TIPA and MCDPA, it must disclose the categories of personal data collected, the purposes for collection, the types of third parties involved, and your contact information. Minnesota adds even more requirements, so you'll need to include your data retention policy and a list of any corporate affiliates involved in the processing. This means you'll need tight alignment between your legal, IT, and operations teams to ensure your disclosures reflect reality. Both laws introduce mandatory data protection assessments. These are not audits for compliance sake, they are structured evaluations of the risks and the benefits of a specific processing activity. And you'll need to conduct assessments before engaging in high-risk data uses, such as targeted advertising, sale of personal data, processing of sensitive categories, and profiling that could result in harm. These assessments must be in-depth and repeatable, and in both states, a single assessment can cover multiple processing activities, but only if the risk profile is consistent across them. Now, the cost of non-compliance. So up to $7,500 per violation. In Tennessee, enforcement falls to the state attorney general, who grants a 60-day window to cure privacy violations before penalties are imposed. Minnesota also delegates enforcement to the Attorney General, but takes a stricter approach. Businesses will have a 30-day cure period, but only for violations discovered before January 31st, 2026. After that, it becomes discretionary, so you might not get a second chance. So businesses should work towards compliance by conducting a full data inventory, understanding what data they collect, where it resides, how it flows, and who has access to it. They then need to assess whether the current practices align with these new requirements, particularly around sensitive data, automated decision-making, and privacy notice transparency. Finally, engaging with legal, security, and operations teams to ensure policies, contracts, and assessments are not just in place, but defensible. Because when it comes to data privacy, compliance isn't just about avoiding penalties, it's also about building trust with your customers, your partners, and the market. Need help operationalizing these laws? Talk to our compliance experts today.